Hello everybody. Today we will start with general provisions of Transfer of Property Act. In the last lecture, we have dealt with the basic introductory part of the property, but in this lecture we will come to the general provisions. Basically in this lecture I will dealing with section 3 of the Transfer of Property Act, in which different definitions are given below. So here let's start with this lecture series. So in the section 3 of Transfer of Property Act, the first thing I'll deal with actionable claim. So here we will deal with the explanation part of the actionable claim. So section 3 of Transfer of Property Act, according to this act, actionable claim is a legal concept, and according to the said provision, the actionable claim means claim to any debt. So what the actionable claim is basically, it is a kind of claim that we arise for any kind of debt other than the debt secured by mortgage. So it does not cover the kind of debt which is already secured. This is basically a kind of claim for unsecured debt. So here you can see the debt secured by mortgage of immovable property. By this drafting you can understand that movable property is basically put in the security for mortgages, or whereby the hypothecational place is basically for immovable property. So here the movable property has put in the security for the purpose of pledge. So what is pledge basically is to put the security, and in return you arise, what you get is debt. For a debt particularly, but actionable claim does not dealing with mortgage, pledge or hypothecation. It basically deals with a kind of claim where there is no security, and you can say this is unsecured debt. In the next slide, now we will deal with the case laws, that is Jugal Kishore Saraf versus Raw Cotton Limited. In this case law, the Supreme Court has held that these things like decree or judgment does not come into the depth of actionable claim. So these are not the depth of actionable claim, because there is a kind of fixed or you can say that fixed compensation. The compensation term does not come under the kind of debt, because there is no fixed monetary things. So there is difference between right to sue and actionable claim. We will deal it in the next slide. In this part, we will see that Motilal in versus Radhilo. In this code, the apex court held that the right of claiming damages, whether it arise out of contract or unliquidated damages arising out of tortious liability, cannot be regarded as an actionable claim. So here we can see the tortious liability, where there is no defined amount of damages. In this case, there is no arising of actionable claim. But what they are actually, there is right to sue. You can see in the tort law, there is a term is UB just EB remedium. Where there is right, where there is wrong, there is remedy. So basically, when something happen in the tort things, or if there is something damages arise in that thing, so here there is no such kind of monetary which is fixed. And but in this case of actionable claim, there is a kind of monetary which we are dealing with are fixed amount of monetary returns. So the latter part, section 130 to 137, deals with actionable claim. What are the various way to transfer the actionable claim? So we will deal it when we'll do with actionable claim part, but right now we'll dealing with the definition clauses. So there is difference between actionable claim and right to sue. And in Motilal versus Radhe, it was held that actionable claim is transferable, whereas right to sue is not a transferable thing. Next is, on the contrary, right to sue is given under section 6E of Transfer of Property Act. The power given to the people by ruling authority to implement the possible action of an unlawful matter. So where there is a kind of unlawful matter, there is a right to sue, right to sue against that particular person. Next is, right to damages occurring after the occurrence of a breach is not actionable claim, but it is merely right to sue. So where there is breach of actionable claim, it is also a right to sue. Mere right to sue is not transferable. In the case of Union versus India versus Sri Sara Mills, it was held that bare right to actionable claim, to damages for breach of contract, claim to damage for the tort, all of these are right to sue but not actionable claim. In the next thing, now we will deal with instrument. The things which are defined in the section 3, the next thing is right to, that is instrument. So to understand the term instrument, you should understand the term document as well. So what is document is basically? in the Indian Evidence Act, if we can see, the term document is defined under section 2, where it is defined in such a way that documents can be a perpetual things to store the memory. It can be a stone, it can be a kind of paper and inscriptions as well. So document does not mean a kind of piece of paper only, but it basically refers to the things in which we can perpetually store the memory. So instrument is also a kind of document. So you can say that the instrument is a species, whereas document is the genus of that thing. So every document cannot be instrument, but every instrument is a document. So here we can see the in Transfer of Property Act, basically there is two type of instrument, that is testamentary instrument and non-testamentary instrument. So these are two types of instrument, and the Transfer of Property Act basically deals with testamentary instrument. What does testamentary instrument means? In general sense, it means will. Okay, but overall it also consists inheritance, insolvency, forfeiture, sale of execution of decree, or by will. There is a various mode to transfer the property from one person to another through the process of instrument, basically. So these are testamentary things. What happened here is, basically, when we make the will, the transfer does not implement or come into effect at the random point of time. It actually come into effect after the death of the person. It takes time to come into effect. But in the testamentary thing, you can see in the next slide, basically. But when it comes to non-testamentary instrument, the time we sign the document, the time we transfer it, it come into effect from that day only. So here, these are the types of non-testamentary instrument, that is sale, mortgage, gift, exchange, and charge. We will explain about all these things in the upcoming lectures. So in the next slide, you can see the term attested. What the term attested basically mean? If we go through, the basic meaning is to certify a document. But when we come to the concept of the term attested, it means there are several types of terms. You can see that executant, attesting witness, attestation, attested. What these are basically means? This means that there are the two parties, A and B, for example. If there are two parties and the document for the transfer of the property will be through the document mode or through the instrument that we have already learned. What instrument it will be? It will be a non-testamentary instrument. So here, if you see, the party who assign the witnesses to come and sign the documents are the executant. Whereas, who are the attesting witness? The witnesses who sign the document are known as attesting witnesses. And what are attestation is? The process of doing all these things, to calling the witnesses and the signing of the document. This process is called attestation, and the document which is signed will be referred as attested document. The next is, what are the essential of attestation? It is very simple. You can understand it even by reading this, that it must have signed. Without signature, how the document come to the validity? Obviously, you need to sign the document. You need the witnesses to verify that the document is not arbitrary. It is a valid document. So next is the attestation by two or more persons. So there should be at least one person from both sides of the party. At least there should be two persons who are attesting the document. The next is, the sign must have been done in the presence of the executant. So what this line is actually explaining is not just about the presence of the party who wants that document to be attested and the signing witnesses, but other thing is that there is no need of that all the witnesses will be in the same time and the signature will be held over there. The document attestation will be held over there. But the necessity is that the party should be there, the executant should be there. So if a person wants the document to be attested, he can call witness A and attested the document, then he can call the witness B, then the document will be attested. No need of calling all the witnesses all together. The next thing, if we refer the case law Abdul Jabbar Sahib versus Venkat Sastri, in this case the court held that if attesting witness has no intention or knowledge, then the attestation won't be considered as valid. It is very reasonable to understand that the witnesses who are signing the document should have knowledge of the fact that what are written in the document. So the term amino attendi, this maxim is basically means consensus ad idem. You can say the intention should be same. The one who want the document to be attested and the one who is signing the attestation should have the same intention in signing the document particularly. The next is one thing I wanted to be clear that there is no need of signature only. You can mark the impression as well. Thumb impression is also valid. The kind of image is also valid to make the attestation. The other thing is Kumar Harish Chandra versus Bansidhar Mohanty. In this case, so basically in this case it is about interested party. In general, interested party are not allowed to be a testing witness. But whereas there is one exception, here you can see that a moneylender gave some money to the mortgagee. The moneylender gave some money to the mortgagee and he gave the money to the mortgager. Hence the moneylender was a testing witness and he became the interested party. So here you can see the moneylender is also an interested party because he gave the money to the person and he is currently affected if the money would not be returned. So here the Supreme Court held that the interested party can also be a testing witness. Here the interested party allowed to be a testing witness. The next thing we will dealing with notice, the term notice. So what the term notice basically means, to have a knowledge of the fact and circumstances. So here in the last part of section 3 deals with the term notice. Notice is mentioned in section 39, 40, 41, 53 and 53A as well. We will deal with in slide by slide, lecture by lecture. Here the term notice describes a requirement that the party in dispute must be a reasonably prudent to understand. So the person in whom the word not notice has been signified means that the person should be a reasonably prudent man. Reasonably prudent, which means that the person is have a rational mind to understand the judgment, to understand the fact, to understand the circumstances, what they are going through. The legal processes basically that is that comes under the knowledge of that person, particular person, about the fact, about the circumstances as well. What are the types of the notice? The types of the notice basically can be divided into, categorized into actual notice and constructive notice. The term actual basically means that the notice or the knowledge or information have came to the person informant directly. Direct process, there is no such presumption or assumption. But when it comes to the constructive notice, court impose, there is no such direct convenience, direct convenience, but what it actually is that there is a thing of presumption and assumption of that particular thing. So the court basically infers that there is a notice and the court presumes that the person is actually notified and they are not allowed to disprove it. Basically, in the case of Plump versus Fluid, it was held by the court that the constructive notice itself is an evidence of notice. There the court will not allow the person to disprove it. So what the constructive notice basically means is that a kind of notice where there is no direct information, but the court impose that the person is actually notified even without the notice received directly. You can say it is an indirect notice. So what are the criteria for that? In respect of constructive notice, these things are important. For example, if a document is already registered, for example, if there is person A, if there is person B and C. So, if the property belongs to B and it registered, A cannot sell it to C. If C buys a property from A, then what is there? There is a kind of constructive notice will be viewed against C, because that document that the property is in possession of B is already registered document. C is liable to inquire about the property before purchasing. The next thing are willful abstinence from inquiry or search. So here what is thing is that the person with the intent or willfully have abstained to receive the notice. For example, if there is a summon from a court and the person denies to accept the summon from a postman, what will be this? It is that the person have noticed that the postman bring summon to that particular person, but he willfully abstained to inquire from it. So what is it? The court will presume that summon is served successfully. And the next thing, gross negligence. In the same example, if the person does not have the notice but he willfully or there is no such intention behind it but grossly have a negligence to receive that, what will happen? The difference between both the sentence is that the process of intention basically. If there is intention to willfully abstain, then it will come under the first clause, and if there is gross negligence, the graver form of negligence, then it will come under gross negligence sentence. Then what is in the both case? We will presume that there is a constructive notice to the particular person. The next thing is document compulsorily registrable. I have already given the example of that. And the next is actual possession. What the actual possession means. For example, if a property belongs to A in a case and the property is possessed by B, so the A, if he direct to sell the property to particular person, the person is liable to inquire why that property is in the possession of particular person. It is the liability of that particular person, that transferee, to know that whether this property belongs to that person or not, belongs to A or not. If its property is in the possession of someone else, he should have knowledge of that thing, that the property is in the possession of certain person that might be belongs to that person. So it is the liability of the person who is purchasing that particular property to inquire about it. So if he denies to inquire about it, then we will bring it under the actual possession concept, and it will be notified that person knows about it. The court will impose that you cannot disprove it. The next thing is notice to an agent. If a notice is served to an agent, it will be assume that the notice is directly served to the principal only. There are certain exception about it, but it will basically, what the general preview is, if the person is notified to an agent, it will be notified the principal as well. So in this case, if the agent has doing fraudulent act, or if third party along with the agent is conducting any fraudulent act, in that case only the principal will be not presumed as have served with the constructive notice. And these are the concepts which we have dealt. In the next part we will deal with the general principles of the Transfer of Property Act. Thank you.